Okay, folks, what I'm doing is I'm waiting to see if our numbers go up a little bit here. It's like I said, we have a special guest tonight, and so let's see if anybody shows up. And I was just trying to, because this is kind of a sudden thing, and we're running a little bit late. And in the meantime, I'm going to turn on my monitor to make sure that this is working the way it's supposed to. Now, I am live from Ocala, Florida. Uh, about 4 miles or less from the courthouse. Uh, got myself a room up here, but I am with my mystery guest, which I will be sitting down with in just a minute. Um, okay, TN, is my audio working? Because that's basically what I need is an audio check. Okay, do I have audio, folks? And welcome, Sam and Linda. Okay, mystery guest, come on down. I'll introduce my mystery guest. And slide on in here. Woo. And for those of you who don't know, this is Kim Pacazio Esquire. She is, oh, look, Task Force is in here. Um, Task Force doesn't like you.
Oh,
She
sorry.
talks about Germany and all that stuff. It's just one of those things. So, anyway, what I'm going to do is I'm going to let Kim talk about how the trial should work um, going forward. So, Kim, over to you.
Okay. I didn't know I was going to talk, but
Yeah, you're going to
okay.
talk.
All right. So I think, as everyone knows, Neely is going to be on trial tomorrow. It is a murder trial, and she is being charged with a first-degree murder, and that is an intentional homicide. Just so everyone knows, the death penalty is not going to be at issue as a potential penalty because the state would have had to give notice of intent to seek death, 45 days for the arraignment, and that didn't happen. So death penalty is off the table, but life in prison without the possibility of ever getting out of jail is on the table. Florida does not have parole. Instead, we have probation that may follow if you get out of jail. So if she were to be convicted, she would likely spend the rest of her natural life in prison. So I believe that she has given an intent to seek what's called she's going to be putting on an NGRI defense, which is not guilty by reason of insanity, and potentially any other defenses that she may have. I think she had initially spoke about compulsion, but you can't do compulsion and not guilty by reason of insanity. So she's going to have to pick one. But just so that everyone knows, if you're going to put on a not guilty by reason of insanity, that means that you've already admitted that you have committed the murder. You've admitted you've done the crime. You admitted that you shot Chris Hallett, but that you should not be held criminally responsible because you were suffering from a mental disease or infirmary at the time that either number one, you did not know what you were doing, or number two, that you did not know what you were doing was right or wrong. So she's going to have to bring expert testimony in order to prove that she was suffering from a mental disease or infirmary, or and that she either didn't know what she was doing at the time or did not know the difference between right and wrong at the time. If she were to succeed, and that the jury holds that she was not guilty by reason of insanity, then at that time the judge would not set her free. We can all remember John Hinckley Jr., who shot Reagan. In that case, the judge, just like in that Hinckley case, would put Neely in a mental hospital for some time period. She would not again be tried for the offense. That would only happen if she was deemed to be incompetent. And she has been deemed competent to stand trial. There is a difference between competency to stand trial and not guilty by reason of insanity. So she's already admitted to, if she's bringing that defense, and she's going to bring that defense tomorrow, she will be admitting that she actually shot Christopher Hallett. It's just that should not be held criminally responsible.
Okay, now, so tomorrow we're going to have jury selection.
Mhm.
Under normal circumstances, how long should that take?
It would depend on the complexity of the case. If there are two attorneys involved and this was a murder trial, like it is, it would normally take days. I mean, as you guys may remember, Casey Anthony trial, the Nicholas Cruz trial, there would be days and days of choosing a jury. Oh, I'm going in and out. So in this particular case, since I don't think Neely would not be competent to do the voir dire process, and that's voir dire of the jury means that both sides, both the state of Florida, which is the prosecutors, and Neely, the defendant, who's unrepresented, gets to ask the jury certain questions in order to determine whether they want to select that person for the jury. And in a capital offense, which a first degree murder is a capital offense, it doesn't mean that death penalty is involved, but it's a capital offense. She would get 12 preemptory challenges, and that means I don't want you on the jury and I don't have to tell anyone why. And there are always unlimited challenges for cause. So if someone came in and said, I used to work for Christopher Hallett at the auto parts store, wherever he worked, then that person clearly would be let off the jury for cause. So there's an infinite amount of challenges for cause to exclude jurors from the jury veneer. And there will be 12 peremptory challenges unless there are alternates, which there will be. And then each side gets one more peremptory challenge for each alternate. And so tomorrow, although it usually would take days and days if we were dealing with competent attorneys, since Neely's, I believe that this will probably be, less, not even a full day. I think that the state, in typical cases, even cases that I do, we would have jury experts, and we would have spent thousands of dollars having jury experts help us choose questions and choose jurors and which ones to give a peremptory challenge. But in this case, that has not been done by the defendant. And there's a famous saying that your case is won or lost once the jury pool is selected. And so that is usually the case. So that's happening tomorrow.
Okay, now, the prosecution, when we get to the opening statements, the prosecution goes first, correct? Generally?
Yes, the state will go first. They have the burden of proof to prove that Neely did commit the crime, and they always go first. And then the defendant will go second. I'm assuming that she has prepared an opening statement. You may wonder if she starts going off in a tangent about child trafficking and endochrome or whatever the heck that all of that stuff is. If she goes off on a tangent, it will be up to the state attorneys whether or not to go ahead and object to that opening. Usually attorneys that I deal with, we don't object in other people's openings because they're usually appropriate openings. But since Neely isn't a licensed attorney, she will have a difficult time probably staying on track. And alternatively, the state attorney could just let her go so that the jury could see just how crazy she is. But that could be a double-edged sword. Since she is mounting an NGR defense, you don't want her to sound too crazy to the jury. So instead, I think that the strategy call would best be served with the state attorneys if they were to object and then not allow her to get out all of her points that she wants to make about child trafficking and mole children or whatever the fuck that all, I'm sorry, whatever all of that is. And they will most likely then get all of their objections sustained by the judge, meaning Neely would not be able to go into those areas. And then she would effectively have lost her entire script, and she would be probably very off kilter, lose her composure, and quickly sit down. That would be the best strategy call, in my opinion, for the state.
Okay, now when the medical experts get in here that the state hired, I gather they're going to argue that even though she may be quote unquote insane, she's competent to stand trial and she meets the criteria for knowing right from wrong, and that what she did was not, you know, not a good thing to do.
No, murder usually is not a good thing to do.
Well, that's obvious.
Yeah.
But they will say that all this stuff that she's doing just shows that she has been influenced by a certain political philosophy and opinion of how the government works, and that she's not insane to the point where she's not competent to stand trial, or where she would be held accountable for her actions and not get this innocent by not guilty by reason of insanity.
Mm-hmm.
Now, we went through this earlier. Could you go through what you believe is going to be the potential witness list?
Sure. So if anyone thinks that this is going to be an exceptionally short trial, I do not. If you look at all of the witnesses that the state has already filed, anyone can look up the docket of the case and see the things and motions that have been filed. Most of the documents can be read by the general public. You would go onto the Marion County clerk of court website and then go to court records, put in her name and press enter, and that would give you the whole docket. And if you look at the docket, you'll see numerous times where the state had filed what's called supplemental discovery. And that's where they are required to disclose to the other side the witnesses and the evidence that they may intend to put forth in trial. Now, there are many, probably over 50 witnesses that they have listed in the past as potential witnesses. There were like 30 cops in one of the supplemental discovery disclosures. But I think that if you think about it rationally, they would probably have, let's say, 14 witnesses. So that's going to take more than a week, and I can see it taking, up to 2-3 weeks. So if I were the state, you'd necessarily have to bring the 2 eyewitnesses, the Shannon, I don't know her last name, and the minor child, who were eyewitnesses to the crime. You would then bring the first responders to the scene so they could explain where they saw Chris, how they cordoned off the place as a crime scene, what they did first, second, and third. Then you'd probably have at least 2, if I was going bare bones, at least 2 of those guys, including the ones that spoke with the eyewitnesses there at the scene. So you would need, that's 4 if you count the witnesses, and then 2 of the cops that were first responders. Then you would need the medical examiner, that's 5. You would need probably 1 or 2 cops from Georgia who had done the initial arrest of Neely in Georgia, because she may have made incriminating statements at the time of the arrest, etc. Then you would need the detectives who would have interrogated her. I don't know if they're going to bring an FBI agent. I think that one had questioned her in the jail.
Yeah, the one FBI agent did question her
Yeah.
in Georgia before she was transferred.
Okay. So it could be him.
Mhm.
So we've got at least, 4 or 5 cops there that may have questioned her. And I said the medical examiner. We've also got most likely a ballistics expert. We'll have a fingerprint expert. We'll have a DNA and trace DNA expert. We've got at least 3 psychologists. Usually there's 3 on each side. The defense would bring their best. I don't know how many they're going to bring. And Neely's attorney, before she fired him, had hired witnesses to corroborate her NGRI defense that would state that the people that she was hanging out with had brainwashed her effectively, and she went down the rabbit hole with the QAnon or the right-wing extremists ideology, where she thought that everyone was children were being trafficked by DCF and others, that her own children are being trafficked, and the entire, what I call QAnon without the Q, right-wing extremist ideology. And I plan to be doing a seminar on this topic, which is QAnon without the Q, and to let judges and lawyers in probably early in 2025. So that's why I'm here, is to do some research in order to help lawyers and judges handle this type of defendant who would believe in endochrome and mole children and these wild, wild, eccentric theories that unfortunately people have brainwashed them into believing. They usually have lost their life, their family, and as we see with Neely, she's lost her liberty because of it.
Okay, now in the situation with, yeah, you gotta quit doing that.
I'm sorry.
She's doing her witchcraft. Poo-poo. Anyway, uh, Neely apparently hasn't done the proper procedure for calling witnesses. And, is there a chance she's going to be able to call any witnesses at all, or how's that going to work?
Well, if she intends to call a witness, that witness would have already had to been disclosed in discovery a while ago. There's always discovery cutoff deadlines so that everybody on each side will know what witnesses the other side plans on bringing to trial, and they would have an opportunity to depose them, which is holding in a deposition, answering questions under oath with a court reporter present. So if witnesses were not disclosed earlier than probably a month ago, then they will be off limits unless there's no objection by the state. However, if witnesses had been listed by Neely, she would have to subpoena them, and they'd have to be served by a subpoena. And she has to, since she's elected to represent herself, she has to figure out the subpoena process. And I don't believe she's done that because I had not seen any subpoenas go out. They could have been listed on the docket. I did not see any.
Okay, so we're
If someone shows up voluntarily, for instance, then she could call them to the stand. So that would be the other alternative. So yes, she could have witnesses if she chooses to bring them
so she's
they came
basically
voluntarily.
too late to.
To name any other witnesses that had not already previously been disclosed. Yes, that would be too late.
Yeah, because what I'm getting at is since she has not subpoenaed these witnesses to appear, it's too late to do that.
That's correct, unless they showed up voluntarily. And it's my understanding.
Well,
I think I'm on the witness list, and I'll be there. So
yeah, well, same
she
here.
wants to call me up. I'm right here. Let's go. Let's go.
Yeah, that ought to be interesting if either one of us get up there. But and then so we get all the witnesses called, they testify, and everybody does their direct and cross and redirect. Then we get the closing arguments. Same situation again. So
yes,
go through the closing argument.
Yes.
So he gets up there. He says, "Okay, you've heard all the evidence. Blah 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 blah. Now find her guilty, and so forth." And she, if she decides to, she'll get up there and do the same thing. Say, you should find me not guilty, and if you don't, then you. If she decides to do it,
yes,
and then we get to, I guess it's Brady instructions to the jury for when they go up in the back to deliberate. Normally, this is done ahead of time, where both sides sit down and say, "Get back here."
I keep walking out. Maybe I'm not close enough. I don't know.
Anyway, my train derailed again. Well, we get the Brady instructions to the jury. Now, can you get into that a little bit?
Sure. And before we go there, a lot of people have asked me, since Neely is unrepresented, how is she going to cross-examine herself and put on if she chose to testify? So if an unrepresented defendant chooses to testify, I'm going in and out, chooses to testify, then they would simply, usually how it works is they get up on the witness stand and they just tell their story. They just tell their narrative. And then the state attorney is the person that would then cross-examine them. So Neely doesn't cross-examine herself or her own witnesses. The state attorney cross-examines her and her witnesses. So that is how that would look in practice. With regard to the jury instructions, usually that's another day or so of haggling, usually if there were lawyers involved, with the judge as to the appropriate, I'm going out, I'm sorry, I'm not even moving.
No, you're wearing blue.
Oh, is that it?
Yeah.
Okay. So if, with regard to the jury instructions, there would normally be haggling if oh boy,
Yeah, don't worry
I'm
about
going
that.
visible. There would normally be haggling between the lawyers and even briefs filed, etc., as to the appropriate jury instructions. I don't know if they're going for a lesser included of man one, manslaughter in the first degree, or second degree murder. I know there is an indictment for first degree murder. Usually, how that works is there could be a second degree murder component because she was first charged with second degree murder. And then there was a grand jury impaneled, and then she was charged with first degree murder, which would show a premeditation. By the way, premeditation can be 1 minute, it doesn't have to be hours long or days. If she showed up there with the intent to kill, that even had a 1 minute of premeditation, then that would be a good first degree murder charge. And with regard to the jury instructions, Florida has, just like other states, standard jury instructions for criminal proceedings and for civil proceedings. And so the judge would then get proposals on which jury instructions to give to the jury, and the judge rules on the most appropriate ones. And then the jury will go back with those jury instructions and deliberate.
Okay, and so then the only thing that comes up is so the jury goes, deliberates, come out, and in the event that she is found,
I'm going to go put on a different color shirt.
okay, yeah, she's going to go off, and I'm not sure what's causing that. I'm use, I'm not using a green screen. I'm using a software that kind of puts in the fake background, and it's the blue must be what in the blue spectrum because you have two different kinds of green screen. And what I'm going to do when Kim comes back, I'm going to open it up for you folks to ask questions. She can read off the thing here, and we'll go that way. Now, I am going to be in court tomorrow, obviously, to watch the jury selection process. And when they take breaks, I will come out and I will um, give an update. Now, I'm not sure how I'm going to do that yet. Um, I may set, because I'm doing this off my laptop and I don't know how I would be able to do this on my phone with this service that I'm using, but one way or another, I will get the information out to you folks, primarily through Twitter if I don't do it here. Levi, I don't know. Levi asked if there's a possibility of Neely supporters attending the trial. Uh, that's always a possibility. Anybody can get into the court as long as they behave themselves and there's enough room for everybody to be in there. Now, there has been Presto Changer. She's back.
I'm back.
We're going to try green this time, I guess. And so that's, we'll just have to see because I don't know how many people she has down here in Florida that support her. Most of the people that support her are from out of state. So, we got however long this trial takes to find out. Now, you guys can go ahead and ask questions of Kim. She can read the.
I didn't even read
this
that
is
yet.
the comment section here. I'm not
I just saw someone ask, is Tim Holmseth going to be there? Well, if he is there, he has an active warrant in Florida. So if he is here in Florida in a courthouse, which would not be too smart, then I have in my possession a certified copy of the active warrant for his arrest out of Broward County, Florida. I also have a protective order that's still active against him. So I would show that active warrant to any sheriff there. They would arrest him on an out-of-county warrant, and then he would be transported to Broward County, where Broward County would then deal with him.
Okay, somebody asked about Mr. Knowles. He was one of the witnesses, and again, we don't know who's going to be called and who's not, as far as whether Kirk Pendergrass is going to be called, the spy pen lady, Neely's husband, and so on and so forth. That's something we're going to find out when they get called. Um, well, anything's possible, but he does. Tim Holseth does have the warrant
Mhm.
in the state of Florida, so if he shows up, he risks getting arrested.
Yes.
So that's one of
I
these
would
things
I
we're
would
gonna
do
be watching.
everything in my power to ensure that he was taken into custody.
Okay, we got any more questions? Now, as Kim said, this trial may take several weeks. Now, I can only be there this week. I've got an extremely heavy schedule, so if when it comes Friday and the trial's going to go over into the next week, I am going to um, cover this the best way I can from Orlando. And there's going to be times where on a Thursday or Friday I might be able to come in and do 2 days a week. It just depends on how this goes. Now the local newspaper, the Ocala Star Banner, is covering this on a daily basis. So what I'll be doing is looking at the Star Banner and check with them and see what they are saying about what happened in the court. And I have one or two contacts within the court that might be able to tell me some of the things that's going on.
Okay, so Kim, can IBT be charged for her phone calls to the jail and her influence over Neely? In my opinion, no. I don't know. I have not heard her give legal advice. She is acting like a friend who would say, you should do this, you should do that, as people would do with their own family members. So she has every right to do that. Someone who would be practicing law without a license would be doing more than that, would be charging, would be going into court to represent people, etc. So
Yeah, this was the situation
Yeah.
with Chris Hallett, by the way,
yeah, so
as
I
he was
think, yeah,
acting as
exactly.
a lawyer.
So I am taking the position that I don't think that person, if this is the Kukunakas, I think she pronounced it Kuku Nike, is
Of
how she
course, I
pronounced
think,
it.
or something
Yeah,
like
and
that.
so
It's Greek.
if I'm mispronouncing her name, I apologize. But I believe that, in my opinion, at least from what I've heard, and I don't listen to her lives or anything. Occasionally, I'll hear a phone call that she has with Neely, and that's nothing more than anyone would do with their own family member, is give them advice and tell them what they should or shouldn't do.
Okay, and we
So
got a
no,
question.
I don't think she's interfering at all.
Did Neely really put you both on as a witness? Well, she filed something that it's got a whole bunch of people. She's got Donald Trump on there, governor of the state of Florida, as well as me, Kim, and several other people. The problem is, again, is neither one of us has gotten a subpoena to appear. We haven't gone through the process where the prosecution can come in and ask us questions. So at this point, unless we get up there and say, "Hey, call me,"
But even then, if the state,
Well, it's not
the
gonna-
state could
it's not gonna
object,
happen.
because that would not be a timely disclosure of a witness.
right? So at this point, I don't think.
But I'm happy to go.
A
on the
lot of
stand
people
and testify
are going to-
about anything she'd like me to.
Yeah.
So I hope she calls me.
Yeah,
I'll put the case to bed. How about that? Go right to bed.
Yeah.
Yeah.
No, at this point, I don't think either one of us are going to be up on the witness stand. So that ship has sailed. And what else we got? Because
Who's Kolohi C? This one.
how did Cyber Citizen and MK Ultra stuff do? None of that's relevant. We're not going to, the state's not going to allow that. All they're going to do is they're going to show her connection to QAnon. They have pictures from her Facebook that Tim Holmseth is raising hell about, and that's basically it.
I agree. Not relevant. The judge isn't going to let her go there.
So they Yeah, Levi Page is saying
It's
about
Ashley.
people accused.
Ashley.
Well, Tim
Hey.
Holmseth has accused me of stealing a gun from Phil McConnell, coming down to Florida and killing Chris Hallett. The only problem is it's her husband's gun. That's his sidearm from the Coast Guard. That information is in Discovery in case anybody wants to go look for it. And I did a segment on gun, which I explained all that. And when they were arrested and when they were detained in Lowndes County, Georgia, the gun was in the car. And there's blood spatter all over it. So that shows that the gun in her possession had Chris Hallett's blood spatter on it from blowback that you get when you impact somebody. Remember the OJ trial that came in and got into that pretty detailed. And they have her DNA from the gun as well. And so you got, uh, yeah, she is innocent until proven guilty, but as a 13th juror, we in the public can make our opinions as to where we believe that she's guilty of this based on all this monumental amount of evidence out there.
And I don't know if Chris Hallett's mom is still alive. Do you?
No, I don't. See, the thing of it
Question.
is this happened 3 years ago, and she's in her 90s. And so, and that's a complete unknown. And I don't know if they've done anything with the house. It was a duplex. I'm sure the son may have gotten rid of the house. But again, we don't know, and I also don't know if the son is going to be there. I would believe that he might, but no information about that so far.
With regard to Tia Williams, I believe asked the question, is there any way to listen or watch the trial? I don't believe so. I don't believe it will be put on Zoom. And so I guess you're going to have to just.
My discussions with the court is that they don't have televised proceedings. There's a couple reasons for it. Number one, they don't have the facilities. None of the local media or national media is going to cover the case. Plus, since a minor is involved at the time of the case, they need to protect her privacy rights as well. So they basically have made the decision that there will be no recording or any of that. Now, what might be done, and I can't promise this, is they may allow me to live tweet from the court. And at the very least, I can text from the court to my Twitter account during breaks and stuff like that to give kind of a summary. And I'm also going to get on the air and give a summary.
With regard to someone asking about, is it Field's old channel, Field McConnell's old Able Danger channel? It's my understanding that was a channel that was founded and owned and created by Eager Beaver. If anyone remembers him, Gordon, whatever, from Canada. And I don't believe he was willing to give Phil McConnell access to that channel after he was finished with his criminal proceedings. So that was unfortunate for Phil McConnell. That's my understanding.
Yeah, that's correct. That he basically took the channel back, and I do believe that there is an effort to come up with a channel for Phil McConnell that
in the meantime,
Paula Blades has something to do with.
Paula Blades does have Field on at least, I think, once a week on their channel.
Mm-hmm.
And he speaks at length and answers questions, etc. So if you look on Paula Blades' Twitter or know of her, I think she's on Rumble and on YouTube.
Yeah, so we're just, you can go over to the two channels that Paula operates and get updated on what's going on with Field and some of the other stuff that she discusses. Sam, I don't know. Her husband, from what people are saying, is critically ill with cancer, and so I don't know what his situation is. Yeah, Align Radio is the one that you go to if you want to hear Phil McConnell or get information about him.
And that was from Honeybear. That's correct.
Yeah. Okay, now at this point, what I think I'm going to do is I'm going to go ahead and sign off, and because I'm going to prep for tomorrow and all that. I will be at the courthouse in the morning. I'm going to try something a little bit different because be the pre-court. I will be. Um, I will be.
You just answered the phone. Can you press it and hang it up? That what you're.
Yeah, I'll call you back in a little bit. I'm on the air. Anyway, the way this system works up here is I'm not going to be able to go on the server I'm using right now unless I do it during lunch or something from the courthouse, which I may do. And I may also try to live stream directly to Twitter from the courthouse as well. And I'm going to do that part at the beginning of, before I go into the courthouse, because then it's just too much to carry this laptop in there. But I am going to kind of get clear with the court what their policy is on using tablets and stuff like that to text out various things. I've been told because I've been properly credentialed that I can do it, and I'm going to verify that tomorrow. So I would suggest to kind of monitor my Twitter account in case I'm able to give live tweets, but I am going to broadcast live briefly, like I did once before, um, from the entrance to the courthouse before I go in, obviously.
And everybody is saying goodbye and thank you. And love seeing everybody. And we'll probably see you tomorrow night.
Okay, so please like, subscribe, hit the notification button, and share. And I will see everybody tomorrow before, possibly during, and after. Each night at 9 o'clock while I'm here, I will be doing a summary of everything that happened in the court. And there will be that. Now, I think Kim's only here for 1 or 2 days and then she's going back to Florida. So she will not be on again. She's a
I'll
woman.
try to get back, but I have a trial schedule, so
Yeah,
I can only come for 2 days.
She's got a job to do, so. Anyway, so okay, we keep getting an uninvited guest, so what can you do? And so see you tomorrow. I should be on the air around 7 in the morning.
Everyone have a great night.
Yep, have a great night.